So now that we've advanced past knowing the character that you're in, whether it's that medical professional or just a percipient witness, knowing the facts, all the universe of facts that would be in fair consideration for this witness. Not every fact in the case, but every fact that this witness is responsible to know. And then knowing the parameters of what you're going to do with your attorney. Here we're talking about the actual expectations of this presentation on direct examination. Now, this is an introduction course. There are other videos that I have that talk about direct examination in particular. And of course, the rules of evidence are going to bear on direct examination, exhibits, how you lay the foundation for exhibits and present exhibits such that they come through your witnesses on direct examination most often. That's all part of it. But I want you to think about, and it's something we talked about in an earlier video called professional presentations, the key here is, can you prepare this where it's like a script? Question from the attorney, pause, tight, concise response from the witness, whatever that witness role is, pause. Next question from the attorney, pause. Response from the witness. And have this back and forth presentation of questions and answers. And one of the ways I talk about that, especially to help new law students and new students in mock trial understand it, is thinking of every witness as having a leash. Don't stray too far. What we want to do, and when this does not work out the right way, I would say, as the attorney presenting, Officer Jenkins, what did you do when you arrived at the scene? Now, I could tell the rest of the story if I'm Officer Jenkins playing that role as a witness. I can tell you about when I got there, what I saw, who I talked to, how I conversed with others, what I did when I left. I can give a 3-paragraph answer. And new people to mock trial, even new witnesses that are not adequately prepped in real life, they give these long, long answers, and it's susceptible to objections. Objection calls for a narrative. Objection, this is a narrative answer, and some of them will be sustained because the objecting party, the opponent, as well as the court, wants the information to come out question, answer in bite-sized pieces. So the leash, what I do to prep my own witnesses or what I do to prep my teammate as a witness in mock trial is to say, I'm going to ask you a question. And what I want you to do is hold it to just what's responsive to that question. And if I want more on that topic, then I'll ask more questions. So, instead of what did you do when you got to the scene, instead of 3 paragraphs of information, maybe you can talk about one sentence. When I got there, I tried to survey exactly what was going on and who was in charge. Now, obviously, that's not the whole answer of what this Officer Jenkins did at the scene, but because I know my attorney's expectations, because we've prepped for this, because we've talked about it, I know there's a bunch of questions about the scene that are follows. Who did you then talk to first? I found the evidence tech who was in charge, who was marking where the evidence was. One question, one bit of information. Who was the evidence tech? That was Specialist Jones. What had Specialist Jones done by the time you got to the scene? So it's one question, one bit of information, that's the leash. Maybe with expert testimony, maybe with some specialists, you might give a little longer leash. Maybe they can have a sentence or two. But for the most part, one question, one bit of information, allow the attorney to do their thing and ask the next question is really good advice, and breaking it up that way. What I see is mock trial teams say, what'd you do when you get to the scene? Offer 3 paragraphs of information. Meanwhile, the attorney in a mock trial who's being evaluated isn't having a chance to ask the next question. And it turns into, okay, then what? And what happened next? And you're depriving them the opportunity to actually do something and score points as an advocate. So craft direct examinations as question and answer with one piece of information. And if I want to spend time on it, I give more questions to a given topic. It's really great advice for real witnesses. If you're going to be a real witness in an actual trial, having an understanding with your attorney of, I'm just going to answer the question you ask and I'm going to provide one piece of information. I'm going to operate on the assumption that if you want to keep talking about that you'll ask 10 questions, 20 questions more on that topic. And if you want to move on because it wasn't that important just arriving at the scene, and you want to get to the witnesses. Were there any witnesses at the scene? Yes. Who was there? Name the witnesses. Were you able to speak with those witnesses? Yeah. So I can get to the part that matters and I didn't have to deal with a 3-paragraph answer. You're trying to be as efficient as possible. And part of your attorney expectations is this leash of one bit of information for one question on direct and allowing the attorney. So if I'm hearing people in practice in mock trial, if I hear a witness's answer get too long and have 3 sentences, I say, try it again, break that down. You only give witness one piece of information, and you should ask three questions to get that same piece of information out if that's all something that you want, if that's all within your expectations as the role of attorney. Here's some goals, and I put it as an acronym. Think of CARS. Some goals for your script, your direct examination with your witness. You and your witness are going to work as a separate little team within your mock trial team. You're the prosecuting attorney. They have someone on the team playing the victim. You're the defense attorney in a civil case representing a company. They're going to play one of the decision makers in an employment discrimination case. They're going to play the CEO. You're going to spend time outside of practice separate perfecting this script, this question, open-ended questions, who, what, where, when, why, describe, explain type questions, and those leashed one thought, one concept, one answer for each, right? Were you able to find anything when you entered the house? Well, answering that direct question, were you able to find anything, or did you find anything when you entered the house? I could say, yeah, I found this and I found that and I found that and I found that, and go into a big answer. If I'm trying to keep it to what's responsive though, did you find anything when you entered the house? Yes. What did you find? I found several items in the back bedroom. What was in the back bedroom? That's where I saw the gun, the little baggies that were known for distribution of drugs. I found some notes, and I found something with the defendant's address on it. I can talk specifically, and I made it into 3 question and answers as opposed to giving it all up right away. I allowed the attorney to do their work of having questions and me giving shortest response, one idea piece questions. So the goal for CARS is this. Aligned with our talk about professional presentations, I want to prepare like crazy. I want to have it where it's almost a teleprompter script for, I know the exact wording of the question that's going to come from the attorney presenting my witness testimony on direct examination. And similarly, he or she knows the exact answers that's going to come from me, from the witness, right? We have it scripted out, but the art is, can you know exactly the question coming, know exactly the witness answer that you intend, but make it sound conversational? As soon as it gets robotic, the same way that an opening statement, if it looks like I'm either reading from notes and just reading off something I wrote on a piece of paper on a different day and it sounds like this and no one's interested in it, or I think equally bad is I've memorized it and I'm looking at these mental teleprompters up in front of me and I say, my closing argument sounds a lot like this because I'm really just trying to remember it and I'm not being conversational. I'm not talking to anyone, and it has the same effect. Same thing with direct examination and the part that we can plan with our colleagues, with our teammates serving as witnesses. We want it prepared. We want to work on it. We want to get the best questions possible, the most efficient questions possible, these tight leashed answers that are responsive, that give us what we need for our case theory and our case theme. But it has to sound like a conversation. And we have to picture that there's an audience, jurors in a real trial, but jury evaluators that are sitting in that same seat who are watching this and hearing the facts for the first time. It needs to be interesting to them. It needs to be conversational. So we need to prep it like crazy where it's a script, but that script has to come off as conversational. Really hard to do, and that's why mock trial requires so much practice. This is your goal. Can I know exactly what's saying, but make it sound like we're having this conversation? What happened next? And then where did you go? After, talking to these witnesses, what was the next step you took in your investigation? It's this, I'm really interested to find out what happened next because you're having this conversational question and answer dialogue that is taking me sequentially through the information that's important to come from this witness. The A in CARS is aligned. That is, you as the attorney, as the team, as the witness on this team in direct examination, you've made decisions about what parts of this testimony are aligned with the way you see the case. What is aligned with your case theory and your case theme? So again, it's those concentric circles. There's a million facts of the case and a huge fact pattern. And if you just presented all of them indiscriminately and you just said every drop of information that's in this mock trial fact pattern, I'm going to have come out of a witness's mouth at trial. That way I don't have to make any decisions. Well, you're not going to fit it in. They all have time limits. It'll be a 5-hour trial. It ain't going to happen. So you make decisions about what pieces of the mock trial fact pattern come through in witness testimony and what smaller piece comes through this witness. And maybe they're the most important witness. So you get 10, 12 minutes with them. Maybe they only contribute 1 or 2 things, and you can do a direct examination that's 5 to 7 minutes, and you've made it efficient. And they might have the same 20 pages of deposition or have a whole bunch of reports that they're responsible for, or gave a single space detailed 5-page statement to the police. All that information is not part of your direct examination. You're making choices. What limited portion of it are you presenting? And you're presenting the stuff that is aligned. How do you win this case? What is your case theory? How have you explained this case for the jury? What is your case theme? The information is aligned with your direct testimony. It's the stuff you can control. You can control your opening statement, control to a large extent your closing argument by what you present by way of exhibits and by way of testimony. Make it aligned, make it all sort of line up with what you have previewed in opening is coming, and then in summation and closing argument, what you're telling the jury and explaining to the jury what happened at trial. For direct examination, it has to be responsive, and some of this comes with the lesson that I started with the leash. Whatever the question is, make sure the answer actually, maps up to it and is responsive to that question. I can't tell you how many times when it's overly scripted where the witness has stuff that they want to answer and kind of get out of their face and want to talk about, but it wasn't time yet. Tell me about your background. Where did you go to college? Well, I went to college here, and then I did this, and then I did a residency, and then I went to medical school, and I've been at a fellowship. Well, none of that was asked. It was, where did you go to college? It was a specific question. Don't bite off more and don't go on past your question, because that gets everyone in trouble. Now all of a sudden your attorney had as a next question, what did you do after college? Did you go to medical school? If you've already answered it, they got to think, oh, I can't ask that anymore. I can't, they had the question and answer balance already struck. And if you're taking on too much or answering 3 questions ahead of time as a witness, you're not doing anyone any favors. So respond to just the questions. And I think you can, this is a point to score points. You can almost exaggerate your responsiveness. Did you find anything at the scene? Yes. What did you find? Several items in the back bedroom. What did you find in the back bedroom? Response. Clearly, did you find anything at the scene? It's easy to say, yes, I found these 5 items. But if you think about just being strictly responsive, did you find anything as a yes or no question? Yes. Allow the advocate to answer, to ask a next question about what do they find. And it comes off more like a direct examination. It comes off where you, the witness, are pausing, and it shows that you're prepared, you're conversational, you're aligned, and you're getting to it. Lastly, for the S in cars, it's specific. You need to be specific. Direct examination and assuming this character, knowing this character and knowing these facts, it's not a time to generalize. It's not a time to, I'm going to casually refer to what's the facts of the case. So that is, if I'm Detective Jenkins and I found 6 items in the back bedroom, I don't want to be like, well, I found a gun and some drug paraphernalia and some other stuff. Yeah, that's a truthful answer, but if you know this character, if you know the facts you're responsible for, and you know the parameters of the witness testimony that you've taken on in direct examination, you wanted and you made a decision that you wanted all 6 of those items described. So don't generalize. What time did you get to the house that night? It was around 4:30. Well, if the fact pattern says 4:35, because I looked at the clock, you say that. So try to get it as specific and as tailored to the facts. If it helps you, and if you've made the strategic decision that this is the question we want and this is the response we want, don't pave over that. Don't generalize. Don't make it. Don't confuse conversational with casual Don't, or generalize. No, conversational, but super specific answers consistent with the facts. You're going to know these facts, you're going to know these characters, so you might as well get it down to it. And for some specifics, check out some other videos that are on my YouTube channel about refreshing recollection. Because if there is a specific time that's important to you both and you drop it on game day, it was 4:35 when you got to the house, and you say, what time did you get to the house? And you know there's a specific time, there's a mechanism for that. And there's actually a way that you can do it with your colleague that looks really good. I don't recall. Is it your testimony today that you don't recall the specific time you got here? Yeah. Did you say something like that before in an earlier statement? I did. Would looking at that statement assist your memory on this topic? It would. Can you please look at the statement? I'm directing court and counsel to this particular page and this particular statement. Looking at that statement to yourself, can you read it to yourself and flip it over when you're done? It flips it over. Did looking at that help your memory on this topic of when you got to the house? It did. When did you get there? 4:35. So I have an auto process of forgetting any specifics, and I make sure that my real witnesses know that process. Don't worry about it. If you forget something, we have a way to get to it with these simple steps of refreshing recollection. But I also know from my mock trial witness, if we get nervous on game day, it's more important to be specific. If you don't recall a specific, say you don't recall, and we'll get to it through this process rather than say, it was sometime in the afternoon, and then you've generalized and you've made our case weaker. This is probably the hardest thing. It's one of the hardest things to do with real witnesses, where you're trying to anticipate, here's where I think the other side's going to go and cross. They're gonna try to get you, and they're going to try to attack you and cross. We know from TV and the movies, everyone sort of sits up in their seat and pays attention, because now it's like, well, the other side, the defense attorney, gets to cross-examine this prosecution's witness, the victim, and ask them a bunch of questions, and they get to they're a little faster, and they seem to have their voice up, and they're confining them to yes nos. It's this drama point. But really think about it. What do you anticipate that they're going to go after in cross-examination? And if, I don't want to oversimplify it, but it often breaks down into two groups. They're either trying to elicit favorable facts, stuff you didn't cover on direct examination because it favors their side, and they will use leading questions. They'll aim for yes answers, but they're just getting out the stuff that you did. You said you got there at 4:30, but you actually, 4:35, you actually didn't enter the house until close to 6 because you were meeting with other people on the scene. Right? I'm asking a leading question. The answer is yes. So I didn't cover that in direct, and it's favorable to the defense side to say it was actually 6 o'clock by the time you went in the house. There's not much to do with that. So tell them you're prepping your witness. You're going to say, hey, they're going to go over the fact that we're talking what time you got to the scene. They're going to talk about what time you went into the house. So you should expect that, answer it truthfully, and probably keep it to some short answers that are, yeah, yes, I can't do anything about that. Those are the facts of the case. When I say trust redirect, this is really important. Some competitions won't allow redirect. If you're doing it, you should do it in a question or two. But if there's some way, the way to think about it, if you're the proponent, if you're the one that's putting on the direct testimony, and you've sponsored this witness and you've prepared this witness, that's your colleague on the mock trial team. And, in cross-examination at different points, they have something to say in explanation. They have a way that they could say, yeah, I did say in an earlier statement that the light was turning red, but there's a because and there's a reason for it. And the cross-examining attorney does a good job of just confining them. You said it was turning red, right? It was turning red. Not that it was red, turning red, right? Yes. There's an explanation, but if you're doing a good job in cross-examination, you're not going to allow the witness to explain it. Your witness, and to be a solid witness, if there's an explanation to be offered, it's not going to happen on cross. Could have happened on direct, but if it's new information and we're kind of dealing with it now, I'm not going to be able to explain things, and I shouldn't force myself to explain things on cross. I don't want to try to talk over people and try to win as a witness or try to play attorney. Yes, I said it was turning red because and you jam out your response, and then you have the attorney objecting that you're not being responsive or whatever. Instead, trust redirect. If there's an explanation to be offered, that it's going to come through your partner, your trial partner, the one on your team that's presenting as the attorney. And an effective redirect question, when you are cut short like this, and if it matters to your case, counsel on cross-examination asked you about the color of the light and what you saw, and asked you some questions about whether it was red or turning red. Do you remember those questions? I do. why did you say it was turning red? So that why question is going to say, I said that because. That's going to come on redirect. It's not going to come on cross. So you got to learn to prep people. What's the stuff they're going to be going into? They're going to go into this area, this area, this area. Those are the three. And you got to say, and if there's an explanation, let's save it for when I get back up. Let's save it. So I talked about favorable facts, and you're going to have kind of short answers to those. The other one is, they're going to try to go after your credibility. Maybe you have a prior conviction. Maybe you've lied before. Maybe you have inconsistent statements. You got to know where those things are. Obviously, you might not cover that a statement's inconsistent in direct examination, but they're going to explore it in cross. They're going to go after the fact that you said turning red versus red today, and we got to expect it. And when you get into it, it's still shorter yes, yes, yes type question answers might be the ones that work. Really the place to protect against in cross are the rollover questions. It's really all your fault, isn't it? And you were negligent in this car accident and everything's your fault. Well, that's what the whole trial's about. So you're not going to say, sure, yes. That might just be a short answer of, no, it's not my fault. Well, you were the one speeding on that day, weren't you? Yes, I was speeding. So it's all your fault. No, it's not all my fault. So I can still handle it in yes, no questions, but you got to know when the question's trying to get too much and when it's sweeping and they're asking you as the witness to roll over, or it goes to the ultimate issue at trial, what the whole trial's about. So this one for protecting on cross, we have a little acronym too. So think of SPIN, and the R, spinner, stands for redirect, and remembering redirect if it's allowed in a competition. But here's what I want. I want to give the way I think about it for my witnesses. Again, I don't play attorney if you're on the witness. Don't try to win from the witness stand. You can undercut most of what they're trying to do in cross-examination just by giving short answers. You saw the demonstration I just did was yes, no, yes, no. I'm just going to not agree to the way they frame the case, right? This is all your fault? No. And I'm not going to offer an explanation. If it's important to give an explanation, it's going to happen in redirect. And I talk about these short answers as giving no rope. Oftentimes when we try to do too much, or we try to advocate, or we try to win from the witness stand, what we do is we provide too much information. This is all your fault. No, it's not my fault because it's actually the person that's on your side, and they're the one that did this, and they should have been looking. And when I give that answer, that's not short, that has a bunch of things. Oftentimes in that answer, I'm providing the cross-examiner, I'm providing the attorney with rope from which to hang me in the questions that follow. I tell my trial advocates and folks in mock trial that they got to pay attention when they don't get a yes answer and they get something else and they get a whole sentence. Pay attention to whatever comes up in there, because I bet you there's something used. I bet you there's some rope to use in subsequent cross-examination questions. I say the P in SPIN is to pick spots. If they're trying to get out favorable facts and they come from the facts, you got to the house at 4:30, but you didn't go inside the house till 6. That's just a fact. Yes. Don't try to give an explanation. That's not a time to go deny things. You're going to get in trouble. That's a fact of the case. And if they ask it the right way and they ask it, you didn't go in the house until 6 o'clock. Yes. So that means for more than an hour of the time when you were there, you were on the outside of the house. Yes, that's a reasonable inference. I didn't go in till 6, so for more than an hour, I was out. So you can do it in a way. That's not, if it's just favorable facts for their case and it's in the fact pattern, there's a place they can point to. I don't want to stray. I just want to say yes. Because if I say, well, I didn't, I'm not sure when I went in the house. I'm not sure if it was 6. There's a place in the fact pattern where it says that. Now, look at some of the other videos I have. You're going to get impeached for a prior inconsistent statement just because you're trying to weasel on this day and not admitting something that's in black and white in the fact pattern. And it's the same thing that goes to the I. You cannot be inconsistent. And what I mean by that is you've offered statements before. You got to stay true to them, right? If something's bad for you, if going in the house at 6 o'clock is bad for you, it's the testimony. You say yes. You can't be inconsistent, and then you've made it worse by saying, no, I'm pretty sure I went in as soon as I got there. Well, that's making stuff up. It's a lie, and you just made it worse for your team because now you gave the cross-examining attorney an opportunity to shine. Also, what I mean when I say inconsistent is you see this all the time of a witness takes a responsibility, assumes a role, and they're They remember everything. They're professional. They know their character. They know the parameters of their testimony. They just sort of, they assume being a medical professional on direct examination. And then as soon as it gets to cross, I don't remember. I don't know. I didn't do that test. I'm not sure. And you turn into a different witness because it's cross examination. No, you're still a medical professional and you still know everything about your facts. And if they want to ask you something that's a favorable fact, on day 5, his vitals and his temperature actually went down. Isn't that right? Yes. I'm just going to answer it short. It's in the fact pattern. I don't want to be inconsistent, but I'm also not going to take on a different role. I am still a doctor. And how would a doctor handle cross examination? Did the vitals go down in day 5? Yes. That's how they would answer it. And this last one, the N, is just non-combative. I think it goes to as much as when we watch TV in the movies, we think that cross-examination has to be Perry Mason style, stand up yelling. We have to somehow make the witness, fold over and admit that they're not being truthful. It doesn't happen. And you don't, as a witness, have to be combative just because the other side's asking you questions. They might ask 10 questions that are all just favorable facts for their side that are in the fact pattern. You can handle cross by yes, 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 yes. Get down off the stand, no redirect needed, and you guys have all you have for closing. You have everything you needed out of that witness. You did everything that's aligned with your case theory and your case theme. So you don't need to stretch. You don't need to do anything more. You didn't need to get combative. If they see a witness, oftentimes jury evaluators, if they see a witness getting combative and getting into it, and the attorney handling it, and actually they can come out better for it. So why do something that can actually make them score more or be perceived as a better advocate by the way they handled something? If you get a bunch of boring yeses where they got some obvious information out that's in the fact pattern, maybe they haven't scored a point, and you picked your spot to say, oh, now you're going to say that the whole accident is my fault. No, I'm going to pick this spot to say, no, it isn't. Well, maybe they make the mistake of asking you why you feel that way, and you get to give a long answer on cross, which means that's how you win as a witness. If you get to give a long answer because they've asked a non-leading open-ended question like, why is that? Or you give a bunch of yeses and you save it appropriately for redirect. Your attorney gets back up on redirect and says, Your Honor, may I have a brief redirect? Yes. You were asked a bunch of questions about this topic. Why? And you give your explanation. And the last thing you're saying before you get off the stand is something that favors your case, and reiterate why you might have said something. So just think, shorter the better. Don't give any rope for the other side to hang you on later questions. Don't be unnecessarily long or try to advocate from the witness stand or try to win from the witness stand. Pick your spots where you're going to say no and not agree and not roll over to something that addresses the ultimate issue of the whole thing. Be consistent between direct examination, cross-examination. You're still the same witness role. You're still assuming the same role. And for me, I would tell all my witnesses, if you have a choice in an answer to get flared up, to get passionate, to get combative, or to take it as a cool route and be non-combative, take that cool route and be non-combative. You probably give less opportunities for the other side to score points.